Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CA CV19-0336, Frank Toon et al. Versus Donor Network of Arizona. Counsel, we are recording these proceedings, so we'd ask you to please identify yourselves and who you represent at the beginning of your arguments. Also, if you feel comfortable doing so, you can remove your masks during the argument for counsel. That's fine. Each side will have 20 minutes to present your arguments. Appellant's counsel, you're probably aware you're responsible to watch the clock and reserve as much time as you desire for rebuttal. Now, circumstances are a little odd here because you're going to remain seated I don't know that you can see the clock. If you need to stand up to see the clock, or if you just want to ask me how much time you got left, I won't be bothered by that. And I'll try to help you out there, maintain you, keep an eye on the clock. So, also, please keep in mind we've read the briefs and we've also discussed this case in conference. With that, counsel for appellant, you may proceed with your argument. Oh, you're here. Okay,
we may have switched on you.
Okay, sorry, I kept looking at you, so that's okay. We'll go with it. Okay.
Good morning, Your Honors. May it please the court, my name is Melinda M. Sloma. My co-counsel and I, Ariel Amar, represent plaintiffs' appellants Frank and Diane Toon against a case with DNA or Donor Network of Arizona. Frank and Diane Toon are the parents of the decedent Christopher Toon, who's at subject in this case. Christopher Toon passed away on July 20th, 2016 from a motorcycle accident. To preface my remarks, it's critical to highlight the rarity of a case against DNA being pursued, including one being brought before this court. We respectfully submit to this court that the reason is twofold. First, attorneys are reluctant to pursue a case against DNA due to the current holdings in Ramirez. Second, few litigants have the funds to pursue a case against DNA, a company that in 2016 had net holdings of $48 million. Litigants like the Toons find themselves in a true David versus Goliath battle. For the sake of brevity, I'll focus my argument on two issues and stand on our brief for the remainder of the issues. However, I'll be happy to answer any questions that I can on any other issue contained in the briefing. I would also like to reserve 2 minutes for rebuttal if possible. The two issues that I will address today is we first ask that the court find under Ramirez there's disputed issues of material fact that do not entitle DNA to qualified immunity under the Revised Uniform Anatomical Gift Act. I will refer to that as RUAGA if that pleases the court. And therefore request that it vacate the lower court's entry of summary judgment on the issue of intentional infliction of emotional distress. Alternatively, we argue that if the court does not find DNA entitled to qualified immunity under Ramirez, we ask that it overturn Ramirez on the grounds that it violates the anti-abrogation clause of the Constitution. Now, turning to the issue of summary judgment, we submit to the court that there were two main factual issues of dispute in this case. The first was whether Christopher Toon was listed in the Donate Life Registry. DNA, in its briefing to this court, wants this court to assume that that's a given. In fact, that was hotly contested at the Superior Court level. The second issue of material fact in this case is, did DNA follow the requirements of the Revised Uniform Anatomical Gift Act? The one issue that is undisputed in this case is that Christopher Toon was never a donor. And I want to emphasize that. He was never a donor. This is critical when the court assesses this case against the line of cases including Ramirez and Perry, where there was some type of consent, but the organ procurement organization went outside the bounds of that consent.
And so let's back up to your first issue or your first point. Whether you're saying there's a disputed fact as to whether Christopher was listed in the DNA registry. What specifically, what reliable evidence, what evidence did you present that creates a material issue of fact there?
So there were two pieces of evidence. There was the hospital notes from the Maricopa County Medical Center, and there was the testimony of Jeff Delfini, the ombudsman for MVD. Now, if I can get into the Ken King Hospital notes and then the affidavits that followed after that. In regards to Ken King's hospital note, Christopher Toon died at 9:16 a.m. on July 20th. At 10:52 a.m., Kenneth King, the head nurse at Maricopa County Medical Center, makes an entry that he calls Donor Network of Arizona, and he speaks to somebody by the name of Mark Scalise. He puts in there that no, patient is not a donor. Mark Scalise opens a file at 10:54 a.m. in DNA's database. Kenneth King, later, my co-counsel and I met with him at our office, and this is all in the briefing. He signed the first affidavit. He signed that first affidavit after reviewing it and making edits to it. That edited version was submitted to the Superior Court. He said those were my notes that I made, and left it at that. 2 months later, approximately, DNA's counsel met with him. They met with him at their offices, they spoke with him on the phone, and they emailed with him. And in that second meeting, Ken King signs a second affidavit that says, I don't think my hospital notes were correct. But what's critical about this issue is that he reviewed DNA's records. He reviewed DNA's records and said, based on DNA's records, I don't think my hospital notes were correct. Kenneth King was a head nurse at the time of this litigation in 2018 of 27 years. He had never had his license called into question, and he had never had any issue in regards to somebody calling into question his records.
Counsel, also in his deposition, didn't he also recant in his deposition and say, I have no reason to believe that maybe I made an error on that?
He said in his deposition that he thought he made an error. He could have made an error. That is correct. But he also said upon cross-examination that he thinks that the hospital notes could have been correct, and he had no reason to doubt his hospital notes until he reviewed Donor Network of Arizona's notes, which we submit to the court. He's not competent to review.
But DNA's records from that conversation with Nurse King, their records said that he was on the registry. Is that correct?
Their records do not state that, Your Honor. What their records show, there's referral notes and progress notes. In the progress notes, Mark Scalise was the first point of contact with Kenneth King. He opened the file. Later that day, there was a period with parentheses. He testified at deposition that the initial contact is when they find out whether or not the person is in the registry. The evidence that supports that is there's a hospital referral worksheet that he completed. It said at the top 10:52 a.m., which is right in line with what Nurse King put. And in that, there's something that says channel 906. Now, DNA used that to try to explain to the Superior Court, which the Superior Court agreed with, contrary to the evidence we submit, that Nurse King or DNA couldn't have known that Christopher was in the registry because he was only designated as channel 906. But that hospital referral worksheet, getting back to that issue, Mark Scalise said that's only filled out when there's a first call. He testified at deposition, there's no second call. DNA has other notes called referral notes where they state later that in the afternoon they identified Christopher Toon. Another issue of material fact that is important to note in this case is that Mark Scalise testified at deposition that those notes can be altered. Those notes can be altered by DNA.
Okay, let's assume, just to not take up too much of your time that you have allotted, assume you're correct, assuming that Mr. King's statements are valid, that they were not refuted by the deposition. Assume all that. Assume that there's questions of fact. How do you overcome the seemingly, in my mind, extremely broad language of the statute that actually exempts from liability errors, omissions, in essence, in compliance for whatever acts occur. I mean, you explain to me your view of the statute, because for me personally, it seems very broadly worded.
Your Honor, we submit to the court that under Ramirez and the case law, the first requirement that DNA has to prove is that the challenged actions were not in violation and do not exceed the terms of the Revised Uniform and Anatomical Gift Act.
Where does it say that? I'm looking at the last sentence of the statute at issue here. It says all acts and omissions are presumed to be in good faith unless the acts or omissions are done with intent to maliciously cause injury.
Your Honor, it doesn't say that in the statute. It says it in Ramirez's interpretation of good faith in regards to the statute. So Ramirez states good faith extends protection, but where in all instances the challenged actions violate or exceed the terms of the UAGA and are taken out without good faith effort to comply. Here, if the jury finds that Christopher Toon was not listed in the registry, it's obvious that Donor Network of Arizona didn't follow the provisions of the statute.
I understood, but let me go back to your point. I think we're not understanding each other. I'm reading from ARS 36-856 that says, the second sentence says, all acts and omissions are presumed to be in good faith unless the acts or omissions are done with intent to maliciously cause injury. I mean, isn't the key here is what evidence, there seems to be a lot of evidence kicking around there, but what evidence specifically gets you to the finish line on intent to maliciously cause the injury? Because that's what you have to prove, correct?
Your Honor, it is, and under Ramirez, that provision was interpreted by Ramirez as follows, if I may.
Sure.
It's an honest belief, the absence of malice, and the absence of a design to defraud or to seek an unconscionable advantage. We submit that if the jury finds Christopher Toon was not in the registry, then there's no honest belief there. The absence of malice, we submit that by DNA keeping themselves intentionally ignorant or ignoring that Christopher Toon's parents were pleading with them in the event that they find, the jury were to find he was in the registry, that can show malice. You cannot get around malice by deciding to be intentionally ignorant. And that gets into our anti-abrogation argument, where I can't foresee a circumstance where an organ procurement company in this state would ever train, or a representative would say, I don't like you, I'm going to harm you, and we're going to harvest this person's organs or tissues. Because that's currently what Ramirez seems to say in this circumstance. And it's our submission to this court that violates the anti-abrogation clause, if it's interpreted that way. And again, we go back to, this is very different than Ramirez, where Ramirez, there was an organ procurement company and there was a social worker. The social worker had confusion. There was confusion from the organ procurement company to the social worker. The social worker miscommunicated how far and how the extent to what the harvesting could occur. In this situation, we submit there's evidence that Christopher Toon was not on that registry and that DNA went forth and procured that. That's an issue of statewide importance. It goes to the issue of anti-abrogation, and it essentially gives an organ procurement company in this state carte blanche to do what they wish in regards to harvesting organs and tissues. Now, especially in regards to the issue of malice, Mark Scalise testified and Sarah Pace Jones testified that DNA employees are bonused for reducing the procurement to transplantation time ratio. So we submit that there's an incentive to the employees to do that as quickly as possible. One other key issue that shows failure to comply with the registry is DNA provided no evidence. Let's say Christopher Toon was in the registry. The jury says he was in the registry. Under ARS 36-864, if somebody signs up through the motor vehicle department, the organ procurement company has to show that that person was provided proof of notice, inclusion of name on the registry, opportunity to revoke the gift, and instructions on how to revoke the gift. DNA never provided that. DNA also never completed the donor risk assessment interview. which is required under their own standards and is also required under ARS 36-85102 to complete that information form for there to be transplantation. So Christina Nopar, who was a representative, she spoke with the Toon family. She was supposed to complete the social history, the medical history. She signed a document at 4:53 p.m. saying it had been completed, and it's not disputed that it was not completed. She testified, I didn't complete it. That was later sent to the hospital. So again, even if Christopher Toon was found to be in the registry, they still don't meet that good faith compliance with the statute. And Your Honors, I'm going to reserve any remainder time that I have unless you have any other questions.
That's fine, counsel. Thank you.
May it please the Court, Foster Robertson with Lewis Roca Rothgerber Christie for Donor Network of Arizona. Your Honor, more than 20 years ago in the Ramirez case, this Court struck the proper and necessary by statute, balance between litigants like the Toons and the public's need to procure organs and tissues that are transplantable to critically ill patients. Ramirez, with exception to what counsel was saying, is a case really just like this. Ramirez was a case where the plaintiffs alleged that there was recovery of tissue without proper consent, and that is the exact issue that's here. This Court correctly applied Arizona's long-standing Uniform Anatomical Gift Act, stating at paragraph 29, quote, "There is a critical state interest in encouraging organ donation and protecting procurement personnel who engage in that important work." Your Honor, the Act's purpose and its guiding principles have not changed since Ramirez. Ramirez and the Uniform Anatomical Gift Act were mandatory for the trial court and were properly applied by the trial court. At the heart of this case, so my client, Donor Network of Arizona, includes the, quote, procurement personnel that Ramirez says the Act is intended to protect. It is the federally approved organ procurement organization for Arizona. By law, it must establish a registry. By law, it must examine the registry when it's notified of a death. At the heart of this case is this. This is a case about Donor Network's reasonable reliance on a facially valid entry in the mandatory registry. Let me say that again. What we have here is reasonable reliance by Donor Network on a facially valid entry. No reason to believe that entry was invalid until after the fact of this mandatory registry.
So let me ask a question on that, if I can, counsel. So you have the nurse contacting DNA, or the hospital contacting DNA. You have DNA contacting the Toons, and the Toons saying, "We don't think our son was on that registry." The DNA did, after procuring the corneas, did confirm with MVD that Christopher was not a donor. Why would DNA not make that phone call ahead of time when you have a family saying, "We don't think he's a donor, we think there's a mistake"? Does that go to malicious intent?
It does not, Your Honor, and your hypothetical, with all due respect, leaves out some very critical things. Probably most critical is the time pressure here. It's undisputed in this case that corneas, that's the tissue we're talking about here, the lenses of the eye that were recovered, just the lens, not the eyeballs, must be recovered within 24 hours of time of death. And it's also undisputed that the quality of the tissue, and therefore the chance of success of a successful transplant to a sight-impaired patient, is improved if the tissue can be recovered even earlier in that 24-hour period. It would completely undermine the donation process, and organs and tissue would be lost, leading to patients not getting these transplants. if organ procurement organizations like Donor Network of Arizona had to do collateral things in addition to checking the registry. The registry is...
Counsel, we're talking about a 5-minute phone call here, or less, aren't we?
We're not, Your Honor, because you're assuming...
How much time did it take DNA to contact? I'm assuming there's some sort of back channel or back way that they have access to contact DMV without going and standing in line like the rest of us. How did they contact DMV to get this information?
They sent DMV an email on the business day of July 21. Mr. Toon's corneas, Your Honor, were recovered shortly after midnight on July 21. And that was approximately 11 hours after he had died. So we were already halfway through that 24-hour period. It's the middle of the night. There is no mechanism for Donor Network to get documentation from motor vehicle department in the middle of the night. The very next business day, though, at 8 o'clock that next morning, Sarah Pace Jones, who works for DNA and is in this courtroom, contacted motor vehicle asking for the backup material, not because she had a question about whether this was a valid recovery, but because she wanted to be able to show the family that, in fact, Mr. Toon had checked the box. It took motor vehicle approximately 5 hours to get the documents to Donor Network, and early in the afternoon on the 21st, Donor Network had its first inkling that there may have been an error here. Not its error, MVD's error. Your Honors, that was 27 hours. 27 hours after he died. If they had to go through that process every time, the tissue would be lost. The entire purpose of the statute would be undermined.
There'd be other ways that DNA could have ensured that he was a proper donor. That's comply with the statute. I mean, as you know, the briefing is full of, appellant's briefing is full of information about how DNA did not comply with certain procedures that it should have, you know, before the death, about reaching out to the donor to ensure. Am I reading the wrong brief? I mean, the look on your face, I don't know. I mean, they make that argument that that shows a lack of good faith right there. What's wrong with that argument?
Your Honor, Donor Network relied upon the most reliable source there is, which is Are
you saying that that's all they have to do in every situation?
Yes, Your Honor. I am saying...
Don't they run the fear of the risk of losing their license over this?
Your Honor, I am saying that the Arizona legislature, as well as the legislatures in 50 other states, have set up a highly reliable donor registry as the mechanism for determining whether someone is a donor.
Counsel, do you dispute that DNA failed to follow the statutory requirements?
Absolutely. Donor Network followed the statutory requirements in all respects. In all respects. The only standard of care testimony in this case, on this record...
Wait. Standard of care? Why do we need standard of care?
Because Your Honor...
We're talking about there was either compliance with the statute or there was not.
Because, Your Honor, if the question is whether the statute was complied with, that is a question of standard of care. Ultimately, what we're talking about here is a case for intentional infliction of emotional distress, which, as the court knows, requires outrageous or extreme conduct. And it would be unprecedented for this court or for any court to hold that conduct by an I-bank was extreme and outrageous and beyond the pale, which is what the standard is for intentional infliction cases, when in fact there was full compliance with the standard of care. The mandatory donor registry is set up by the legislature. It's the same, essentially, same process in all 50 states, and based on Jason Woody's uncontroverted declaration, which is the standard of care expert for Donor Network, that is the method by which organ procurement organizations around the country determine that someone is in the registry, and that's exactly what Donor Network did. Counsel talked about other alleged non-compliance with the statute and supposedly that Donor Network did not strictly comply with the statute. Well, Your Honor, that flies in the face of Ramirez. one of the issues in Ramirez, and this is at paragraph 12 of the Ramirez decision, was whether a donor network organization like Donor Network can lose the qualified immunity if there was some error in following the statutes. And the court rejected that proposition. Again, this is paragraph 12, and I'll just read a couple of sentences. It says, according to plaintiffs, the qualifying language in the statute means that any failure to strictly comply with the Act's terms deprives the defendant of immunity. And it goes on to say, we disagree. In our view, the qualified immunity statutes are intended to immunize good faith efforts to comply with the Act's mandatory procedures for obtaining and conveying donative consent. So there were no errors here by Donor Network. The error was by Motor Vehicle Department in placing the name in the registry. Donor Network relied upon that in good faith, and that is the established mechanism. Now, I'd like to address counsel's argument about Mr. King's affidavit. So, as I understand this argument, counsel is saying that that there is evidence in this record that Donor Network fraudulently entered a name in the registry because it really wasn't there, and they fraudulently put it in there. Well, there is certainly no such evidence in this record. Let's talk about Kenneth King. Kenneth King was the nurse at Maricopa County Hospital. He made a note at 10:45 he didn't make the note. It was actually an auto-generated note. He just had to press a button, as he explained to us in his deposition. And where he ultimately wound up in this case is saying he believes he must have pressed the wrong button and saying that he was not a donor rather than he was a donor. May it please the court, it was impossible, not just unlikely, not just questionable, it was impossible for Donor Network or anybody to have checked the registry at 10:45 in the morning when he pressed that button. And the reason is because no one knew Christopher Toon's name. He was being identified in the hospital by a trauma name, Channel 906, which is a name assigned to him by the hospital, not by Donor Network, because he had come in on the verge of death, unfortunately, without proper identification, and they were operating on him, proceeding with him throughout the time he died, and then later in the morning under this trauma name. You cannot check the registry under a trauma name, under a phony name. No reasonable juror could conclude that the registry was checked, and in fact, the Donor Network internal documents show that the registry was not checked until the afternoon. So Mr. King's note had to be an error. Mr. King had no access to the registry. The hospital had no access to the registry. He had no personal knowledge of this. When he was asked at his deposition, do you have any reason to believe that Mr. Toon was not in the registry at the time? He said he has no such reason. To rely upon that first affidavit, the one that he has repudiated, the one that he has indicated is
7 minutes.
the one that he has indicated was an error, would fly in the face of Orm School's teaching. Orm School tells us that when an affidavit has been repudiated and the affiant says it's unreliable, it can't be relied upon. And Judge Campagnola properly did not accept the total speculation about this fraudulent entry, this alleged fraudulently entry in the registry. I want to point out one more thing. Can I point out one more thing, Your Honor?
Sure, go ahead.
On this. Don't forget the testimony of Ryan Lawrence. Ryan Lawrence was the fella from the independent company, independent of Donor Network, who kept the registry for Donor Network. And when this all came up in the trial court, was he in the registry, was he not, we went to Utah and took his deposition. And Ryan Lawrence examined the actual backup tape that his company received in the summer of 2015, and he personally observed that the name was on the registry. A year before Mr. Toon passed away, more than a year before he passed away. No reasonable juror could come to any other conclusion, and I'm sorry, Your Honor.
No, I was just going to say, do we know, does the record indicate a possible rationale for Mr. King's first affidavit? Why the
Yes, Your Honor.
changes?
He fully explained it, and Judge Campagnola accepted his explanation of why he made the error. When he went to, and he explained that when he went to plaintiff's counsel's office, he just looked at the hospital records and did not realize that the donor was unidentified. Once he realized that the donor, that Mr. Toon, was under a trauma name all morning long, he realized, well, we couldn't have possibly checked the box properly. Now, let me take you one more step, may it please the court. So, let's say that someone at Donor Network told Mr. King that Toon was not in the registry on that morning. That didn't happen. We know it didn't happen because they couldn't have checked the registry that morning for the reasons I've already explained, and their records show they didn't check the registry that morning. But all of that would be a secondhand mistake. That would be someone at Donor Network saying something that was mistaken and Mr. King relying upon it. Well, if Ramirez teaches anything, and if the statute means anything about qualified immunity and the presumption of good faith, mistakes do not lead to liability for organ procurement personnel. And why is that? That's also explained in Ramirez. Lack of judgment cannot lead to liability because the system would be severely hampered if that was the case. All organs, all tissue have to be recovered under extreme time pressures, often in the middle of the night, just like this one, often when secondary sources like motor vehicle department are not open and available. And if this court were to impose a system on the organ procurement organization in Arizona that would make the process more cumbersome, delay it, make it more expensive, we know what would happen. It's in the record. It's in the declaration of Jason Woody, the only iBanking expert in this case, and he says if organ procurement organizations have to do secondary checking, delay, can't rely upon the registry, organs and tissue will be lost. And I am not overstating it to say that if organs and tissues are lost, the result will be that severely critically ill patients in Arizona will not live.
Counsel,
That's how important this system is. Yes, Your Honor.
What time what time was Christopher Toon identified? At what point did they realize who he was?
Your Honor, he was identified, he passed away at 9:16. The note, that the erroneous auto-generated note by Mr. King was at 10:45. I beg to differ, the 10:56 entry time is not correct. It was at 10:45, and he was not identified in the records at the hospital until afternoon. I can't give you a precise time.
And where in the record would I find that? Do you know?
It's in Mr. King's testimony. Okay. I took him through his deposition elaborately on some records where he wound up, and that's why the light went off over the proverbial light bulb went off over Mr. King's head as he got more into the record. It's not because he was somehow influenced, which is what counsel on the other side of the courtroom wants to suggest. It's because he realized that he only knew this individual as Channel 906, and he couldn't be identified in the registry. Let me touch on a few other things. The anti-abrogation argument, which is what counsel said today, they want to rely upon it as their second major point, that was never brought up in the trial court. It was waived. That was
not even brought up in the motion for new trial?
It was not, Your Honor. The constitutional challenges against the act in the motion for new trial were on equal protection grounds and due process ground. Anti-abrogation was never brought up. No wonder there's not a record developed on this, because it wasn't brought up. Plus, counsel forgot to tell you, but I'm sure you know this already, that the anti-abrogation argument was considered and rejected in Ramirez. You'd have to overrule Ramirez to say that the Uniform Anatomical Gift Act abrogates any cause of action.
Well, we couldn't overrule it. We could disagree with our colleagues, I mean, on that.
Well, you wouldn't want to do that either,
Yeah, we could.
Your
I'm just-
Your Honor.
For clarification, we can't overrule it.
So it was waived, and it was decided in the trial court. Counsel is incorrect when she says that there was a violation of procedures because the social medical history was not completed. What the record shows, and this is also in depositions, testimony by the only standard of care expert, is that had to be completed before transplantation, not recovery, and these tissues were never transplanted. So, Your Honor, we have a record here. The record is the Ramirez case. The Ramirez case and the Uniform Anatomical Gift Act apply not absolute immunity. In the briefing, plaintiffs have referred to this as absolute immunity. It's not absolute immunity. Procurement personnel are held to account if they intentionally or maliciously do things wrong that harm people. But they are given qualified immunity for innocent mistakes. And that's what happened here. We had a facially valid entry in the registry, and they properly relied upon it, meeting the standard of care and trying to do their best. Thank you very much.
Thank you, counsel.
Your Honors, thank you. In regards to Judge Brown's questioning as far as a simple telephone call, ARS 36857C says that a donor or an organ procurement company may presume the documented gift is valid unless a person knows it was not validly executed or revoked. Donor Network knew that when the tunes started saying, I don't think he's a donor, we don't have his signature, his names are not on, the designee is not on the licenses. And they told that to Donor Network representatives. Additionally, Jason Woody, his testimony is inapplicable to this case. And if the court were to view it as relevant to the case, he wouldn't pass a Dalbert challenge. He never looked at the UAGA until he testified at deposition. He has only testified in regards to cleanliness in transplantation of corneas and eyes. Additionally, the donor risk assessment interview, Christina Nopar and then Debbie Treadway the next day sent a form that stated that had been completed. And it was Christina Nopar's testimony that was never completed. Now, turning to the issue of the anti-abrogation clause and it not being brought up at the trial court level, counsel's correct on that. However, this court can review it under Tempe v. Fleming. It's a procedural, not jurisdictional issue, and it can be superseded by the court. This is an issue of statewide importance that the court needs to rule is distinguished from the Ramirez case. In Ramirez, under the anti-abrogation argument, the court said they weren't going to go that far because Ramirez was arguing negligence. And Ramirez was not arguing intentional infliction of emotional distress like this case. So we therefore submit to the court this is distinguished from Ramirez. And again, there was an innocent mistake in the communication from the hospital social worker to the organ procurement company. Finally, Your Honors, counsel spent a lot of time going through the facts of this case. I spent a lot of time going through the facts of this case. It shows that this was not appropriate for summary judgment. The court, under Orm School, in the trial court, passed on the issue of document interpretation, weighing of evidence. The court said, Ken King's hospital notes said Christopher Toon wasn't a donor. Jeffrey Delfini, the ombudsman, said Christopher Toon was not a donor. They didn't issue a license. They had an internal document called the CCI folio detail, said Christopher Toon was not a donor. MBD said we have no records of anything sending over to Donor Network of Arizona, but yet the court came down in favor of DNA. And we submit to the court that this is distinguished from Ramirez. The citizens of this state need protection from a powerful organ procurement company so that they don't have carte blanche in a case where he was not a donor. The family said he was not a donor. There were two independent third parties saying he was not a donor. And we request that the court vacate the motion for summary judgment, distinguish this case from Ramirez, and allow this case to proceed on the merits before a jury. Thank you, Your Honors.
Thank you, counsel, both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. Court is adjourned.